Thank you very much. Welcome back, ladies and gentlemen. We start this session one, comparative analysis of emerging privacy and data protection regimes. And I welcome the following dignitaries on stage. Mr. Sunil Abraham, Executive Director, Center for Internet and Society. Mr. Stephen Mathias, Partner, Kochhar and Company. Welcome, Stephen. Anirudh Rastogi, Managing Partner, Corporate Law and Investments at TRA. Can we see Anirudh on stage, please? Yes. Elaine, Khoo, Regional Legal Counsel, IP&O&T Law Group, Citibank. Welcome, Elaine. Sonal, Basu, General Manager and Head of Legal, US, Mindtree. I am sorry to say that Ms. Priyanka Jain, Head of Legal and Compliance at Experian, couldn't make it from Bombay. From Mumbai, as you know, that we were inundated till yesterday. And organizers such as me were lucky to escape from the city, just at the nick of the moment. So, but we still have about a dozen delegates who couldn't make it from Bombay. Either the flights got cancelled or they just did not want to take a chance. So, both of which are really justified. So, we start this brilliant panel. Sunil, all over to you.
Thank you so much. Good morning to all of you, and thank you so much for joining us in this conversation. On this panel, I think there's a bit of an echo, but on this panel, we're going to be focusing on the future, and India is a good place where one could consider alternative futures, unlike the European Union, which has about 37 years of legacy and history when it comes to protecting privacy, when it comes to protecting personal information. India has what I would like to call tabula rasa, which is a blank slate. So there is an opportunity for us to do what we have done with technology. It's not necessary for us to go through the same evolutionary process that happened in other parts of the world. It is possible for us to leapfrog some of those steps. So I'm going to take this conversation through three threads at least. I'm going to give different panelists an opportunity to answer my questions. The first thread would be around the GDPR itself. That is one vision of what the future could look like for India. That is one vision of an emerging standard and regime. The second thread would be around consent. And then the third thread, I will look at risk mitigation from a contractual perspective as compared to a regulatory perspective. So let me get Stephen to kick off the first thread, which is the thread on GDPR. Stephen, in your view, is the GDPR the model for India? And if not, or if yes, could you tell us why?
Thanks, Sunil. Good morning, everyone. So, as many of you know, GDPR, which is the new privacy regulation in the EU, it will come into force mid of next year. And it's considered to be a modern, kind of refreshed look at privacy law. I've gone through the GDPR regulations. To start with, I think it's definitely an overkill for a country like India, which has no record of privacy law at all. But more than that, no culture of protecting privacy either. And so we're really starting at a clean slate, as Sunil said. So I don't think GDPR in that sense is implementing GDPR in India is the way to go. There could be some benefits in terms of outsourcing to the Indian IT industry from Europe. But again, there are ways to deal with that as a contractual method where the vendor would agree to comply with GDPR. And it's interesting to note there are numerous privacy professionals in India who are qualified on European privacy law, and they are in most of the big vendors in India. Where I think GDPR could be of help is with regard to concepts, definitions, and language used. And I think that following GDPR is a good way because we can pretty much piggyback over the jurisprudence as it develops. GDPR, in terms of the law, there's actually so much more to come, and it's just starting to come out, in the last few months, and it'll keep going in terms of developing jurisprudence around GDPR. So it's not that different from our English common law system, where if we don't have a particular solution under our case law or statutes, then we'd look to English law, which could be persuasive. So I think that in that sense, GDPR could certainly help India.
Thank you, Stephen. Sonal, you've just heard what Stephen said. He calls the GDPR overkill in the Indian context. So what does that mean? Is there any middle ground? Are there incremental steps that we can take? Are there any transitional approaches we could adopt? Would you like to comment on that?
Yeah. So I totally agree with Stephen. Culturally, we are not there yet. So taking the GDPR route would be an overkill, and I don't think we should be that aggressive. Having said that, it's important for us, given that India is the place in terms of industrial revolution, having maximum FDI. So we are advancing a lot, and we need to have a robust regime, if not from a regulatory standpoint, at least from those interim step standpoint, where we do give comfort to all the foreign companies that we do respect the privacy regime. We are there in terms of taking appropriate steps internally to make sure that you are not getting exposed on any front. Now, BCR, Binding Corporate Rules, is the best thing to do in my view. I strongly promote that. Until we get to a strong regulatory regime, I think we could adopt BCR because that gives a lot of, that's, quite strong in terms of having a strong awareness from an organizational standpoint. So BCR is something that could be adopted. I have also, binding corporate rules, yeah. So, binding corporate rules are the rules which which encapsulate the governance which companies have when they transfer data, intra-group data transfer is addressed through those. It's approved by the commissioner, and it is quite a strong, concrete platform for the organization to make sure that they do respect the privacy regime. Now, the other steps which I would really want to harp on is are not reactive steps. I've seen that, and I represent the industry. I've been part of the service provider organization for a very long time. What I feel is we are very reactive. We are not proactive. When something goes wrong, we start thinking about what could have been done. I think we could be more proactive. It's not about having policies. It's about preparing for any of those unforeseen events. So how could we have teams who could deal with those situations? Because we cannot have an utopian state where we could go on the premise that nothing is going to go wrong. We see every day some of the other thing going wrong. Even in today's ET, we saw the data which has been published by Experian is a bit scary, right? So we could have good teams who could think ahead, be prepared in terms of how we could deal with those uneventful scenarios. We could also focus on some additional proactive steps where we engage experts, do due diligence on our internal corporate procedures vis-a-vis data handling, and give comfort to all the buyers of our services, saying that we are prepared and we do mitigate and we do appreciate the privacy aspect, and we are there to take steps on that front.
Thank you so much, Sonal. Elaine, you come from an industry which, if I may say, is not afraid of regulation. You have a long history of dealing with regulators and ensuring compliance. Unlike some other parts of the emerging startup economy, for example, where there is very little experience, could you give us a little bit of a regional perspective when it comes to the GDPR itself? What has happened in the region? Has it been roughly the same, what we see across the globe, or are there something specific about the region?
I'm really, I come from the financial industry, and as most of you would be aware, it's a highly regulated industry across all jurisdictions. So we are, as you correctly pointed out, accustomed to complying with stringent regulations and having regulators in each country have oversight. We are equipped, and in a sense, things like privacy and a lot of data protection and privacy regimes that have emerged over the last 10 years in the region, whilst they are new for the region, we've always internally said it's not that new for us as an industry, simply because as an industry we have historically and for time immemorial have had to deal with privacy to a large extent, and that's to protect our customer information and to deal with banking secrecy laws, and in that respect, it's not new to us. It is certainly, though, a much wider scope. We have to comply, and as a regulated industry, we are accustomed to complying. To the extent we are no longer able to lobby or to influence a change that is helpful for the industry, the approach for most of the financial sector is we will comply. We will allocate the resources and we will comply. And in terms of the GDPR, that's a classic example. For the last few years, advocacy groups, and countries all over the world have really just been shocked at the extent and how wide and how stringent the GDPR applications are. The reality is, it is here to stay, it is coming. We have to comply. So what we have done as an industry and as a firm is in the last 2 years started to put in place baseline privacy principles and policies that we comply with to ensure compliance with GDPR. And in that same way, given that the GDPR standards are really quite high, we have by default then also dovetailed into various emerging data protection regimes. So I don't want to say that it's easy for us to comply. It's certainly not. It is a huge implementation process. Tons of gap analysis we have to do in each country because, as you are aware, in the Asia-Pacific region, there is no rationalized data protection regime. Every country has its own. We have countries that are more established, like Hong Kong, Australia, Japan, Korea, that we are accustomed to that. And then you have countries like Singapore and Malaysia, who in the last couple of years have become very active and have established those systems. But you also have what I suppose we would call the real emerging privacy regimes, where it's not quite there yet. You have sectoral regulations, but not omnibus, clear type of situation. And a lot of these countries, I will cite, for example, Thailand. Years ago, they've put in place privacy laws, but they've never really looked into it, and it's very much been a start-stop sort of thing. Anecdotally, I was informed by our Thai officers that every couple of years, the government, depending on the prevailing regime, relooks at how they want to kickstart that regime again. And then we start looking at the principles again, and we start looking at what is happening in the world, in this case then, with respect to what's happening in Europe, and they start looking at how they might be able to comply or deviate. Unfortunately, a lot of that takes place as a consultative process, and whilst there's a lot of buzz and news about how, yes, we're looking at laws that are going to come into place, the practical realities is that very few of those actually do come into place, and therefore there is a large amount of ambiguity and uncertainty, and we just have to sort of wait and see how that works. As a result of that, the conservative approach would then really be, apply the baseline standards that are high, and we, in that way, are by default in compliance with those. So from a GDPR application perspective for the industry, it is a huge pain point, but it is here to stay, and we have to proceed with that.
So, Anirudh, what I'm going to ask you to do is pick a side. So, on the one hand, you have Stephen, who says that this is overkill, And there is Sonal that says that we should just continue with things like the binding corporate rules, and we don't have to go whole hog with the GDPR standard here. And there is Elaine that has very different perspective, which is give us all the regulation you've got and we are going to comply. We might complain about it, but we are going to comply. And
It's a reality.
because it's a reality. It's a reality waiting for us. So where do you stand, Anirudh?
So we are, as a country, we are clearly not ready for this. Point taken, even from a cultural standpoint, there's, way to go. But I wonder, do we really have an option here? In fact, I would like to pick up a point with which you started this conversation in the beginning, that India really has an opportunity here to invent something new, because we don't have a 30, 40 year of history or an overhang which, say, the EU had, right? And we can really experiment and create something new, and I guess we're going to talk a little more about that in the session. And while that sounds like an extraordinary opportunity, but can we as a country which also, has with a significant outsourcing industry catering to the world, can we really be an outlier not meeting adequacy requirements? And mind you, it's not just the GDPR. The other jurisdictions are also catching up, and if we do not really satisfy the adequacy requirements, I wonder if we can go midway or we can really experiment too much.
Any comments from Sonal, you and Stephen to close this thread, or shall I go to the next? One second.
So I wanted to just add that, that's an excellent point, because in terms of the applicability, for example, the GDPR, one of the things we have to note is that really is if you are dealing with information that is coming out there, when you have, now in this day and age, that is a reality. I think, though, that a lot of countries or firms that do not have to deal with that look for alternatives, right? So alternatives in a way, like, for example, we do have instances, and we have seen with counterparties where the solution for that is to keep the EU separate. So yes, so we have, for example, data centers that are dedicated for the EU, and then we have the rest of the world, where there is some ability then to deviate from those stringent standards. So, yeah.
So absolutely. So some firms can choose to take advantage of the regulatory arbitrage and then carve up their business in different ways. So we'll move to the next thread, and Anirudh, I'm hoping that you can kick this thread off. We'll talk about consent. So when it comes to reinventing privacy principles for the age of big data, machine learning, artificial intelligence. And if indeed we could break away from the European tradition, could you cover some of the proposals in India when it came to consent? I know one proposal has been discussed quite heavily, which talks about almost doing away with consent completely. So would you like to kick off this thread?
Certainly. I think the two concerns I have really with the conversation today, which is largely very unifocal on data privacy being at the center of the entire conversation. And please don't get me wrong, at no level am I challenging the sanctity that one needs to give to privacy as a sacrosanct right. But what I find is missing in this conversation is that, for instance, the tremendous potential of big data for public good, or artificial intelligence, where both these applications rest heavily on the availability of a critical mass of information, a critical mass of data. Now, given the increasing restrictions on what data can be collected, what use it can be put to, subject, of course, to consent being given, and higher threshold for consent, I feel the side effect of it is going to be felt by the AI and the big data industry. And I think in our conversation, we need to just bear that in mind and kind of build in for some kind of outs to ensure that we can provide for for collection and use of data for increasingly high potential, high impact applications. Now, the proposals that, in fact, a very interesting and I guess controversial proposal, which Rahul Mathan speaks about in a couple of his articles, is that he goes on to say that consent is dead. And what we really need is, given that it is just difficult and, to have meaningful consent, he talks about a situation where you can have an increased accountability on the data controller and bring in a reasonableness standard to kind of ensure that the data controller then takes the responsibility to ensure that whatever data is collected is reasonably used in whatever way it can be without affecting the rights of the data subject itself. Now, it's controversial, and while I see the potential in it, I also have certain reservations. And largely, I wonder how the industry is going to take to it, given for one reason, that it will mean an increased liability and responsibility on the industry itself, because now the standard, now the threshold moves, or the responsibility moves from the data subjects to the controller.
So when you said you had reservations, was the increased liability the main reservation you had, or is there others?
Yeah. I wonder how it is going to play out, and will the industry, while it is good for the industry, how do you deal with that?
The operational details.
Yes.
Okay. Elaine, if I may come to you now. So how has your industry dealt with consent, and how has that, what has the approach been, and how has it changed?
Okay, so historically, in terms of consent, the industry and I would safely say in most or all of our jurisdictions in Asia Pacific rely on consent as a basis for the collection, use, and disclosure of customer information. That has always and historically been the case because we are subject to banking secrecy laws in various jurisdictions. The emergence of data protection or privacy, personal information or personal data protection laws has given us incremental compliance obligations because the definition of personal information, personal data is wider, much wider than customer information. The obligations we have under personal data protection laws are also a little bit more stringent. A lot of regulators do take very seriously our notification obligations and the specific purpose obligations to ensure that we are using data specifically for the purposes we say we are using them for. The impact and result of that is higher compliance costs for the industry. We have had to undertake exercises, again, in a somewhat disparate way because each jurisdiction is a little bit different. But the general principle is that we have had to go out and obtain fresh consents that are wider, that deal with personal data. And that goes into the whole range of things. It's not just the customer-facing type of an issue, but we have to also look at how we impose those kinds of obligations on our third-party service providers, third-party partners, and how we build it into our products. So in terms of consent and how we've always historically dealt with it, that is one of the ways in which we dealt with it. Having said that, certainly I would echo the view that I think most professionals and practitioners will agree that consent is really something that really needs to be looked into, and we have to look into the alternatives that are available to just this checkbox approach to consent. Historically, the moment you demonstrate to your regulators that we have these written consents that we have built in and built into our terms and conditions, technically we would be in compliance. But with the emerging trends of data, personal data protection, and a lot more, I would say, as the man on the street, as data subjects become more educated as to their rights, regulators do take it very seriously, and that would mean that I wouldn't say 10-page consents because we don't have 10-page consents, but generally speaking, if you have, traditional consents where they say you've consented to giving me all your data for use for everything under the sun, those don't fly anymore. Those don't work. You cannot rely on that anymore. And that being the case, I would say that I think I would echo the view that consent in that manner is no longer really acceptable. It is, I wouldn't say dead, but it is a different model now. And I think the trend in certain jurisdictions, certainly in established jurisdictions, there's already the ability to obtain information for specific purposes without consent, so by notification, say in Australia, I think in New Zealand. In Singapore, very recently, in the last 2 or 3 months, there have been proposals that have been put out by the commissioner to seek public consultation as to move to a different model, a model in which we're looking at alternative bases instead of consent. Just a little bit of background in terms of, now that is, I think, a strong move that most, that the industry, at least from the financial perspective, I speak at least from my firm, is welcomed, because it certainly is, in reality, difficult to constantly obtain, and it's not meaningful to constantly be saying, oh, we're using your data for this purpose, and constantly updating that is a huge cost. It is also not practical. It does not allow the industry to move forward in a way that is in pace with what the digital economy really is about. With a lot of nations in Asia Pacific looking at being smart cities, with IoT, with AI, and the huge benefits that can be reaped from all of that, it certainly is a welcome move to look at how we can move away from just that very traditional view. So in Singapore, the recent view is that they're looking at maybe towards where consent is not practical, where consent is not detrimental to and adverse to the interests of the individual, where you have notification, where you know, that there is an ability to then say, okay, and there's no deemed consent, then there's an ability to say we rely on just notification as a basis. That is a proposal. There's been public consultation, and I think the consultation period closes sometime in September, and then we will see what the regulators ultimately enact and put in place. The other trend, I think, which is similar to the idea of legitimate interest under the GDPR, would be that in Singapore, as an example, and I cite Singapore because in some of the countries in Southeast Asia, there is an implicit, or not implicit, implied and informal recognition that the commissioner in Hong Kong and Singapore are the leaders in terms of how they move regulatory. So a lot of countries sort of look at how it goes and they take a wait-and-see approach. In Singapore, the other thing that they're looking at is in terms of helping to find alternatives to consent would be what we call legal or business purposes, which is similar to, say, legitimate interests in the EU. However, I would caution that I'm not sure how similar that would actually really be in reality, and maybe, you know, GDPR experts can actually speak to that, because my understanding of legitimate interest, at least in the EU model, is very much balanced against the rights of the individual. So just because there are that there's a legitimate interest, you know, exception or ability to use that, it's still largely balanced against the rights of the individual. Query whether or not that really will be the case in jurisdictions in Asia that adopt that. And I say this because the sense is that legal and business purpose could go the other way. We will definitely need clarity on what they mean by that, how it's prescribed, but it could go the other way. It could be really wide with no real respect to the rights of that individual. It could actually play out that way, and in that sense, then it is quite a deviation from the protections that are afforded to the individual by virtue of that sort of thing.
Thank you, Elaine. Stephen, you've heard a kind of emerging critique of the strict consent model. You've heard that it's too costly, that it's too complicated, that it may not be easy to enforce. You've heard of a variety of alternatives to this strict consent model, strengthening the principle of accountability, strengthening the principle of notice, carving out fresh exceptions. So where do you stand on both the critique and also on the assessment of the alternatives.
See, first of all, I would say that the idea that consent is dead and can no longer be the fulcrum of privacy law is no longer controversial. It's been talked about for some years now, and if you look at emerging jurisprudence, it is moving away from consent to some extent. So if you look at the Singapore regime, for instance, there is a doctrine of reasonableness built into that statute. It's an overriding principle that goes over the procedures of obtaining consent and so on. So it's up to the regulator then to develop jurisprudence around that in terms of what is reasonable and what is not. And as Elaine mentioned about legitimate interest, I think the future of privacy law is centered around the concept of legitimate interest. The sad part is that if you look at GDPR and you look at what are the requirements to collect and use personal information, it's consent or legitimate interest. But then it goes on to talk about use of privacy, which is essential for the service and not essential for the service. If it's essential for the service, you can have acceptance or consent as a condition for using that service. But if it's not essential for the service, then if you make it conditional, then that's not considered consent. So what happens there is that then you would have to satisfy, either get the consent or you would have to satisfy legitimate interest. So I would say to a large extent, consent will still be the model in GDPR, and that's a downside of GDPR. But in many cases, you will have to satisfy legitimate interest. Now, what does legitimate interest mean? That's still to be developed. I've read reports, industry reports where they've collated views of people from the industry. They've said, for instance, that online behavioral advertising is legitimate interest. Now, of course it is, but it depends on what is the situation. If you're, let's say, Facebook, and I'm using Facebook, I'm not paying anything to Facebook, right? So the monetization that comes out for Facebook is my data. So then it's very hard to argue that's not legitimate consent, legitimate interest. So I think as we go forward, this doctrine of legitimate interest is going to become more important, and undoubtedly we as a country need to build our regime also probably around it. So I'd say the world is already moving away from consent as the only means. I would caution, the last thing I would say is that it's not that you do away with consent, but that only consent is not good enough. You still give people the choice of consent. And maybe in 99% of the cases, they don't read the privacy policy, they accept anyway. But some people might want to read it, some people might want to say no, so you still have to give them that option.
Thank you, Stephen, for bringing that thread to a close. And I like the way that you framed it as somebody from civil society. I think you were looking at saying it as consent plus plus, or reinventing consent, or eliminating those parts of the consent model that are not really working for the stakeholders. So that's a useful framing. If I could ask you, Sonal, now to kick off the last thread in this conversation, and then we'll open it out to the audience for questions. Here I would like to explore risk mitigation, and from the perspective of contractual compliance. As a service provider, could you first give us the view from your corner?
So let me take a step back. We are talking about consent. If I were to take an example of IoT, where I have a chip in my car which is tracking my behavior, driving pattern, and then the insurer decides what premium the insurance company would want to impose on me, is not something that I would be comfortable with, right? So where do we draw a line when it comes to consent is something that I would want to focus on as an individual. But as an organization, we spoke about legitimate interest. While we could have a premise where the controller takes accountability and, irrespective of whether there's consent or not, takes the accountability of exercising some reasonable care. But does it stop there? No, because the controller would want to pass on those obligations or liabilities on the service provider. So ultimately, the liability regime gets skewed, and that's the major concern from a service provider standpoint. So what could a service provider do? And I could tell you, based on my experiences, when I negotiate contracts with customers across the globe, and when we discuss the information security or data privacy regime and the liabilities around it, when I ask the CIOs that, what is it that you are doing to protect your data? And don't be surprised. I've got responses like, oh, I would need to look into it, or we are looking into it. It is alarming. So on the one hand, we are servicing clients who are in turn servicing their customers, and then they are wanting us to take responsibility, but when it comes to their house is not in order. So so it goes back to the culture of privacy. Now, there's only little that we could do, given that we do not have a robust regulatory regime. One is contractually, how could we protect ourselves as service providers? What are the obligations that we would want to impose on the customers, the clients, in terms of how they handle the data as controllers, how they would want to deal with it? Are they taking adequate measures protecting the data that they have, and eventually they give us access to? That's one. Secondly, what is it that we are doing as service providers to take care of that data? Are we making sure that we do have adequate security protocols in the organization? Are we making sure that we do have dedicated teams, looking into that data? Are we taking care of the fact that it's not just contractual, there's something that we agree in the contract and then we forget about it, but we are actually sensitizing and creating a lot of awareness amongst the teams who are handling. Are we making sure that the access is restricted to a few people who need to have access to that information? So from a risk mitigation standpoint, it's not just service provider. I would say it works both ways, on the buy side as well as sell side, that the data is handled appropriately. There's enough awareness on both sides on how you deal with that data. From a service provider standpoint, we need to make sure that in case of any unforeseen event, we do have appropriate insurance cover that would protect us holistically. So I would lay an emphasis on the fact that those conversations, which are crucial conversations when you're doing your contract negotiations with the customer, are something that you would need to focus on in terms of what they need to do, what is the expectation from us as the processors, and how is it that we could collectively protect the data, because we need to protect the interests of the end customers. That's what I would say.
Thank you, Sonal. Elaine, Sonal has given us the perspective of the service provider. Would you like to talk about it from the perspective of the customer? Sonal has already said that part of this is a symbiotic relationship. It's not enough for one side of the party to get it right.
Yeah. So that is, I'm taking up on your point about how there is an expectation from the service provider side that the collectors are taking care of the data and treating that the way it is. I would prefer another way to look at it. In terms of obligations, regulatory speaking, a lot of those obligations actually fall on the service recipient, at least in my industry. So as the regulated financial institution outsourcing our obligations or data processing to data processors, the reality is that the banks, the financial institutions, are the ones that are ultimately on the hook based on banking laws, as well as for the purposes of data protection legislation. So that is where we end up having a lot of concerns, because the reality is that we are by law obligated to ensure we comply with those provisions. However, we have to ensure that our processors also have the stringent, robust systems to comply with those as well, because in the event of a breach incident, the folks that get their knuckles wrapped are actually the regulated FIs. So that is where we end up dealing, and then the reality is that for how we deal with that, there is a certain level of risk, passing of risks, which is absolutely necessary, and that we consider that to be built in to the model when you're servicing regulated industries. So historically, we have always dealt with, and it's heartening to hear that service providers recognize the necessity to ensure that they are putting in place systems that comply with what your customers require. And the recognition, I think, should stem very largely from the fact that the ones that suffer the reputational, the wide franchise risks, the regulatory risks, which are for the large part rather unquantifiable, because we're talking about your potential regulatory licenses being impacted, and if you look at like breach events, it's always the customer-facing entity and certainly in financial institutions, it's always the banks that goes on the front page and suffer the repercussions. Now, how we then end up having to deal with that by justifying why and how we have used certain data processors or subcontractors or service providers, if those rigid, stringent standards have not likewise been imposed, that falls on the service recipient. So while I agree, it is absolutely a symbiotic relationship, I think from my perspective, it would be that it's almost a given that the data controller will have those things in place, because regardless, they are ultimately the ones on the hook. The difficulty then is making the other side of the equation recognize that whilst we deal with a lot of, for example, small startups who are not necessarily regulated, nor are they aware that these things are in place. And the challenge there is to ensure that those risks are spread out in a way that is reciprocal, it's fair. It is, So one of the things that we see happening, and you're absolutely right, Sonal, the liability negotiations become very contentious, because it becomes, who's going to be liable for this and how one of the ways we find we have been able to work that out is precisely to work out with providers very stringent standards that both parties are able to ensure compliance and reach a reasonable compromise. The recognition, I do think that in terms of like the outsourcing industry, most players are completely cognizant of the fact that they need to have those things in place. The question I have would be that whilst we are able to say that those processes are in place, it's a matter of monitoring. How you can start a relationship and you can say, okay, we have put in place all these types of processes that are wonderful and that meet the requirements of both parties. The question then becomes ongoing monitoring, and then that goes into a part of the contractual relationship. I think also has to deal very largely with the ability to monitor, inspect, and audit processes.
Stephen, if I can ask you to bring this thread to a close, you've heard two very different perspectives on risk mitigation, but everything roughly within the framework of a contract. Of course, there is the shadow of regulation above, but the level at which we were discussing it was the level of contract. What does this mean in terms of other approaches, such as harms-based approaches to privacy regulation? Is this something that the state should consider?
Sure. So I have two major comments in terms of risk mitigation. I think the first is that the consent model is actually a simple model, because you can program it into your systems and you get the consent or you don't get the consent, and it's an easy yes or no. But what happens as we move towards reasonableness or legitimate interest is it's a principle-based model. and principles have to be fleshed out, and they will change over time. So I think that results in greater risks for businesses, because they have to evaluate whether what they are doing is reasonable and acceptable or not. And they have to also anticipate that a privacy commissioner may pass an order which will say this is allowed, this is not allowed. And then if you've done something that's not allowed, you've transferred data to someone else, you probably need to build in a regime in your contract that allows for it to come back. So I think it's a higher risk model. But the other aspect, in the world of big data, we are moving away from minimalization. And so if industry wants to use data for more purposes, then industry has to accept greater risks. The second thing, what you mentioned about harm-based model, I would recommend that where harm occurs, and that typically would be reputational or embarrassment and so on, there should be strict liability. And meaning that if you've taken somebody's data and you've used it and that person has suffered harm, you pay. We should not attach a negligence, duty of care, kind of standard on there. We should not attach, mens rea type of standard in there. It should be strict liability. Has there been a loss to that person? Yes. Has it been caused by you? Yes. Therefore, you should pay damages. Of course, it's a different matter. India doesn't have much of a damages culture, so what damages you'll get, who's to say, and what kind of court you'll go to, all that has to be determined. The last thing I would say, going back to my first point about risks being higher because it's a principle-based approach, is we need to be more transparent in bringing forth regulation. I like the TRAI model, where the TRAI will come out with a consultation paper. It will call stakeholders to give their comments, and then it will come out with a recommendation paper where it will even document every single person's comments. So if I were to write to the TRAI and give my comments in the recommendation paper, there will be one paragraph saying that Stephen Mathias had this to say. And then they come out with their recommendation, then that goes to DOT, and then the DOT examines that, and then it finally comes into law. And in between that, they can also have an open house discussion. So privacy is a very, it's not a concrete, easily, you can't define standards so easily. And so it's very important to have a lot of discussion between industry and the regulator.
Thank you, Stephen. So we have 15 minutes left in this session, and I'd like to open it out for questions. I had other questions, but I want to reserve at least 15 minutes for questions. So if you could raise your hand, and if somebody could come. Yes, please. Is there somebody with a microphone? With a traveling microphone?
My question is, Stephen said that there has to be some damage to the aggrieved party. But as far as the privacy is concerned, I don't think it has to be, damage has to be proved. I don't want to know anybody about my certain activity. So there has to be some law on this point.
Is there anybody who wants to respond to that? Steve?
Sure. I mean, one aspect when it comes to online behavior, and when you're suffer something, is that the moment you go to court and the moment you take some action, you end up bringing more attention on you, and that could be more harmful. As some people say in the world of defamation, filing a defamation suit hurts you more than just keeping quiet. So that's something we have to deal with, unless you have private courts and so on, but I don't see that in most regimes internationally, so we have to examine that.
Okay, let's collect a couple of more questions. I think the lady on this table, and then the lady on that table, and the gentleman on that table, and perhaps even the gentleman. So 4 questions.
Sure, my question is for the panel. So considering the privacy judgment, and the international regime of the privacy laws, what do you recommend as immediate steps that Indian companies could take to ensure that we are taking care of privacy concerns?
Thank you. The lady on that table, if somebody could take the mic over to her.
Hi, thank you for your points. I just had one question with regard to, again, consent. There's been talk also of the problem of repurposing data, or rather use of data for purposes different than when it was collected. And in that context, the concept of continuing consent, continuing active consent, which is, so my question really is that when such an issue is, say, highlighted by a user, how far is the industry prepared to deal with something like that? And in terms of mitigating that harm, to mitigate continuing harm. So where injunction from a court may not really apply, but how far can the industry really stop the harm that's ongoing?
Thank you. The gentleman on that table.
Hi, this is picking up from Stephen's last point on strict liability for data processing. As most people in the audience are probably aware, data protection is first and foremost about privacy, yes, but also about discrimination in processing and a bunch of these other rights that flow out of data processing. So my simple question is, should liability in data processing be one of conduct or one of result? The reason I ask is because there are two competing forces here. In a world of machine learning, we create sort of algorithmic Frankensteins that can go on to do whatever they please, and they can evolve into ways that the initial programmer may not even contemplate. That's one end of it. The other end of it is obviously today any data is sensitive data, right? Target can predict whether I'm pregnant or not based on the change of my shampoo, right? Somebody can predict whether I'm homosexual or not based on my facial recognition, right? So any data is sensitive data, right? So is it an obligation of conduct or is it an obligation of result, right? Am I required to take certain steps to ensure that the result does not happen, or am I strictly liable in case the result happens? Is that the model that we're trying to propose? The other question that I want to bring up here is also in terms of how the regulator can deal with this. Considering also a lot of industry might not be willing to expose their algorithms to the regulator to sort of conduct a black box audit on how these algorithms are processing. How does the regulator deal with, say, if an obligation of conduct is imposed in this regard?
Thank you. And the gentleman on the table immediately behind.
So I was hoping for a couple of questions, but I limited to one. So the question is to Stephen and the lady besides Stephen. I couldn't catch her name though. So
Sonal.
So should not the organization or any financial institution come up on their own upfront and have a code of conduct or a strict liability, or in a sense where they themselves go to the client and say, yes, this is a tort, this is where we went wrong, and we are ready to compensate. That is one part of it. To maintain a relationship with the client, of course, on a long-term basis, because that not only helps the client, you to retain the client, but also in terms of a long-term relationship with the client that is retained. And the second part is, can monetary compensation be enough for the so-called defamation or the social loss of the client?
Thank you. That's a very wide range of questions, and I'm hoping that all of us remember all the questions. Otherwise, we'll ask you to remind us if we haven't answered your question. Who would like to go first? I'm going to invite all panelists to, okay. That was the first question, yeah. Who wants to? Okay.
Actually, the question from this lady here and gentleman there, they're quite similar. So you said, what could the companies do to mitigate, right? And your question was, how could the service providers or companies be proactive and give the comfort to the clients? Now, given that where we do not have any regulatory protection, I would say that it's not just about having a policy in place, right? Make sure that you execute the policy in letter and spirit. Make sure that you do have technical tests within your organization from a technical standpoint that you implement and check if you're vulnerable or not. Make sure that you do have those conversations with your client saying, these are the steps that we are taking, let us know what else is required from our side, and what is it that you are taking? Are you encrypting your data? Are you anonymizing it? To what extent are you exposing that data, right? Making sure that there are regular audits which are conducted on a proactive basis. It's not just when something goes wrong, we start doing the due diligence and trying to remediate the situation. Those continuous audits, having those conversations with the client on what to do, what not to do, basis what you are doing, and making sure that you are enforcing the policy the appropriate way is something that I would recommend. I would also, to your question, I wouldn't take a step as a service provider and say that I'm doing everything, let me know what else. I wouldn't harp on that only. Rather, I would want to have mutual set of obligations so that we mitigate the risk appropriately and in advance. Anybody want to add?
Just to add
So,
to Sonal.
so we're down to the last 5 minutes, so I'll ask for quick responses from all
Just a
three of
very
you.
quick response that one of the things that I think is actually absolutely necessary is that ongoing relationship, precisely that ongoing monitoring and the ability for the customer to be able to inspect and check on the processes, and in a real way, not just in terms of, oh, we've got all these wonderful policies and they're not actually being implemented, not actually being practiced. That is the real gist, because there's no point having all those contractual obligations saying that you've done that. In an event of a breach, the question then becomes the damage suffered by the customer is actually quite difficult to quantify. So the idea is to try to avoid that incident.
Yes, I'm hoping that you can do all in your response. There were 2 questions from that gentleman for you. And
okay. So to take the question on continuing consent, I agree there should be continuing consent if the purpose of the use of the data changes, then yes, you should go back. And laws should insist on transparency in terms of fleshing out exactly how you're using that data. To the question on, okay.
We'll have to ask you to repeat.
Right, the one on result versus conduct.
Yes.
I think it doesn't matter whether it's result or it's conduct. The question is, has harm occurred? And if harm has occurred, then one should, award compensation.
Yeah, I'll just very quickly respond to the very first question the gentleman in the front asked about harms-based approach, and similarly the question on conduct-based or result-based approach. I think the moment you start talking about privacy as a fundamental right, I think the harms-based approach, I don't agree with it. I think if there is disclosure, I must have a remedy. That's how I would like to look at it.
The Supreme Court recognizes a fundamental right, so you cannot attach it with the harm-based remedy. I can even ask them to stop using my information.
Right to be forgotten is now progressive.
Is one example. Also, just a quick closing comment on that. Harm may not have occurred yet, but with the availability of data collected through multiple sources, we don't know how it can be used eventually. I think that's the big concern around data as well. So,
The way I heard the last gentleman's question was about what can the industry do proactively, and that's one thread that we haven't explored on this panel, which is self-regulation, co-regulation, and so on. Did anybody want to comment on that, the last question?
Yeah, I think there were 2 parts to what he said. The first was bringing out policies and so on. And I think all companies do have privacy policies, so that part's in place. The second one is proactively paying damages for liability. That's not going to happen because no company is going to put out a policy saying that if we violate the privacy policy and you suffer harm, then we are going to pay you damages. So that has to come from the law. But obviously, there is some sense of a contractual obligation that when you have a contract with a customer and you say, we will use your personal information according to our privacy policy, and we will also comply with the law. And if you don't comply with either of those two, then the law should provide the support for compensation to be paid.
Thank you so much, Stephen, and I'd like to thank all the other panelists as well. I learned a lot during this conversation. I hope all of you in the audience also enjoyed the conversation and learned something new. I'm also quite sure that all questions haven't been answered to full satisfaction, so I would request you to approach our panelists during the breaks and take the conversation forward. Thank you.
Thank you. And that's precisely what we also encourage, a lot of networking during the lunch and tea breaks, so that this discussion can be carried forward. And we really appreciate the intense discussions that this session has started, and we hope that the following sessions will also have the same. Thank you very much, Sunil and his brilliant team on stage. Can I request Kanchan to be here on stage, please? Kanchan. One round of applause for the session. Thank you. Kanchan is part of the legal department at Tata Insights and Quants division. I request Kanchan to hand over small mementos on behalf of INBA, please. Thank you, Kanchan. Thanks. Can we have one group photo, please? Yeah. Kanchan, you too.